It's a very pleasure for me to participate in this today's webinar. And I must thank Mr. that brother, what is name?
Krishna.
Huh?
Vamsi Krishna.
No, Vamsi. Vamsi, who came to me and requested to participate in this. I felt very happy. First of all, I must congratulate. It is for the first time that an organization like this which conducting webinar whereby we can communicate with each other without practically meeting at a particular place. And I must thank to the scientists who are responsible for the development of the science in the present day. I must also thank to Mr. Vamsi for utilizing the services of the developed science by conducting the seminar by way of webinar. Now the topic that fell for consideration before us today, as far as we are concerned, is what is the difference between the regular courts and the human rights courts and commissions. Courts have been defined basically under the Constitution of India, secondly under the statutories, CPC, CRPC, and all subordinate legislations. What is meant by courts? The definition court defined is always in relation to the courts defined under the Civil Procedure Code. So therefore, we have a democratic system. One of the category, nature of the state is democracy. Our constitution contemplates in its preamble, we have a country, nature of sovereign, socialist, secular, democratic and republic. These 5 words defines the nature of the state across the world. It has got a wide definition. Secondly, the definition also deals with the rights of the people in the form of right to equality, right to liberty, and right to fraternity, and right to dignity. All these 4 rights have been enshrined in the preamble of the Constitution. So therefore, the object of the Constitution is that the power of the state to protect the rights of the citizens of this country in this fashion. Coming to spread over or to implement the provisions of the Constitution at 2 levels. It deals with the court system, subordinate judiciary and the higher judiciary. As far as the subordinate judiciary is concerned, it starts with the dealing with the sessions judges or district judges, high court judges and the Supreme Court judges. As far as our system is concerned, it is of 3 levels: subordinate judiciary, higher judiciary, and constitutional judiciary. The subordinate judiciary starts from the position of municipal magistrate. We are calling it as junior civil judge, sub-court or sub-judge, we are calling it senior civil judge, and the district judge. What are the terms and conditions to be appointed as a district judge has been enshrined in the Constitution itself. Coming to the High Court is concerned, as per the up to the district level, it is by way of selection by conducting the various types of examination. It is written examination, it is oral examination, and also the personality test, etc. This is up to the district court, district judges. As far as the High Court and Supreme Court judges is concerned, it is based on the recommendations by the collegium. Collegium consists of 3 judges headed by the Honorable Chief Justice of the respective High Courts, and it's 5 judges or 7 judges as per the appointments to the position of the Supreme Court judges are concerned, and the Chief Justice of the Supreme Court will be heading that particular committee. That is also collegium. So this is the mode of appointment of the judges from the subordinate judiciaries to the Constitutional Court, that is the Supreme Court. So the courts have been defined. Now for the purpose of exercising the powers of the courts, to see that the law that has been defined under the Constitution and the preamble of the Constitution, for the purpose of implementation of the same, now under the various statutes, courts have been mentioned. Whenever we say that courts means immediately we have to go to the Constitution, then the Civil Procedure Code and other substantial statutes. So therefore the court is completely different from the tribunal, from the quasi-judicial authorities and the commissions. For example, revenue laws are there. Every authority from the state of MRO to the stage of secretary, they have 2 powers. One is administrative powers. An authority who is to suppose to issue a particular certificate, it is an administrative power under which he will be entitled to issue the certificate, and the citizen concerned is entitled to receive the same. Suppose that validity of that particular certificate is false for consideration before the appellate authority, called a statutory authority under the statute. Either it may be by way of an appeal or the revision or the review. They are called as statutory authorities. Similarly, tribunals are there. Suppose under the Industrial Dispute Act 1947, you will find the tribunals. Tribunals deals with the rights of the workers defined as to who is the worker as per the Industrial Dispute Act. This is the 3rd category. The 4th category is commissions. Commissions of 2 types. Commissions have been mentioned under the Constitution, and commissions have been mentioned under the various statutes, including the Human Rights Act of 1993. The Human Rights Act of 1993 contemplates 3 kinds of rights which govern the area. Number 1, human rights are no difference between the fundamental rights and the Constitution. Therefore, the human rights as mentioned under the Indian Constitution are human rights. Similarly, there are international treaties. Under the international treaties, there are about 6 treaties which have defined as to what are the human rights. The whole object of the human right is a person who has born on the earth shall be provided a full protection by the society, full protection by the state, full protection by the family, and full protection by the individual. No person can be deprived of his human right by any means, either by the state or by the society or by the family or by any individual. Therefore, any element of right of human rights is being violated by anybody, the Human Rights Commission is empowered to deal with those matters. Now, as far as the Human Rights Act of 1993 is concerned, it is at two levels. One is the national level, another is the state level. National level commission is concerned, it is called National Human Rights Commission, and state level is concerned, State Human Rights Commission. Two activities invariably. One is adjudicate the matters by passing the necessary orders or making recommendations to the government or concerned authority to implement the human right of a person who complains before the Human Rights Commission of his violation of his human rights. Secondly, in the larger interest of society, it also has the power to recommend to the government and see that it is implemented. If any of the direction is not implemented by any authority, it can also refer the matter to the concerned court, including by way of filing a writ in the High Court and the Supreme Court under Article 226 and 32. The High Court and the Supreme Court, as the case may be, are respectively, to see that the order passed by the Human Rights Commission is implemented. So it is all powerful. So therefore, only condition is that the person who comes to the Human Rights Commission should be able to, on account of the negligence on the part of a public servant, a citizen's right is violated. That is the precondition. Secondly, even abater also, an authority who abets somebody to see that a particular person should not be provided justice in connection with it before him, it amounts to abatement. What is abatement has been defined as an offence under the Indian Penal Code. So therefore, human rights, scope of human rights is very large than that of the ordinary courts, regular courts. There is no procedure, very easy procedure as far as approaching the Human Rights Commission is concerned. But there is a lot of procedure is there as far as the civil courts and criminal courts are concerned. There is no technicality involved in the Human Rights Court in dealing with the issues. Mere telling us that somebody had bet me is sufficient. Why you have bet me? We have an authority to ask. So therefore, there is no ambiguity. There cannot be ambiguity. The people of this country should know that Human Rights Commissions are there to protect the rights of the citizens of this country. It is very easy. It is not cumbersome. There is no much procedural aspect in approaching the Human Rights Commissions at the state and national.
Can I take the floor?
Yes, sir. Yes, sir. Continue, sir.
Yeah. Firstly, Honorable Justice Sri G. Chandraya Garu, Chairman of Telangana State Human Rights Commission and also former Judge of High Court. Learned Sri Ramchandra Rao Garu, suppose he is supposed to join here. He is a designated senior lawyer, Bar Council of India member and also member of Legislative Council of Telangana. Sri Vamsi Krishna Garu, Advocate, President and Telangana Advocates Association. Learned colleagues, friends, namaste and good morning to you all. Firstly, it is always said that all human beings are born with equal and absolute rights and fundamental freedoms. In this regard, I congratulate Justice Chandraya Garu, taking charge as first chairman of Telangana SHRC. SHRC. And to all here, happy 74th Independence Day. And today we have entered into 75th hour of our independence since 1947. Basically, human rights are moral principles or norms that describe and are regularly protected as natural and legal rights. Human rights are rights inherent to all human beings, regardless of race, sex, nationality, ethnicity, their language, their religion, or any other status. Human rights includes the right to life and liberty, freedom from slavery and torture, freedom of opinion and expression, the right to work and education, and many more. Everyone is entitled to these rights without discrimination in an independent free country. On this, international laws on human rights lays down certain obligations on the countries to respect, protect, and facilitate the human rights of citizens. I take these three words: respect, protect, and facilitate. Respect means countries must refrain from interfering with or curtailing the enjoyment of human rights. Secondly, protect means countries are to protect individuals and groups against the human rights abuses. And thirdly, countries have to facilitate and take positive action for enjoyment of basic human rights by their citizens. On these guidelines, Universal Declaration of Human Rights by UNO was made in 1949. It is 60 years from this. Universal Declaration of Human Rights is still more a dream than reality. Violation exists in every part of the world. For example, worldwide, individuals are tortured or abused in at least 81 countries worldwide. They are facing unfair trials in at least 54 countries as per the survey. And individuals are restricted in their freedom of expression in at least 77 countries. Not only that, women and children in particular are marginalized in numerous ways. The press is not free in many countries, and dissenters are silenced. The protesters are silenced. Too oftenly to the permanent, and human rights violations still plague the world today. But when it comes to India, the Constitution of India is the longest written constitution of any sovereign country in the world. Chapter 3 of our Constitution enumerates fundamental rights in part with international human rights. And also, Honorable Supreme Court ruled in Kesavananda Bharati case that basic structure of Constitution, including the fundamental rights, is unalterable by a constitutional amendment. Hence, these fundamental rights cannot be changed by any government in rule in India. And India also has the Protection of Human Rights Act 1993. As per this act, human rights means rights relating to life, liberty, equality, and dignity of individuals guaranteed by Indian Constitution and also embodied in the international covenants. So our protection of human rights speaks both. One is about the Indian Constitution rights guaranteed, and second is in the international covenants like UDHR, where the human rights are being guaranteed. We are all born free and equal. First, we should understand that. We all have our own thoughts and ideas. We should all be treated in the same way. There should not be any difference. Particularly in India, the most significant human rights issues include police and security force abuses, such as extrajudicial killings, disappearances, torture, arbitrary arrests, detentions, rapes, harassments, life-threatening prison conditions, and sometimes, pre-trial detentions, lengthy pre-trial detention goes on.
I am Anand Rao, Judicial Member, State Human Rights Commission. I'm very happy that my chairman already spoke at length about our functions and all those things. And in continuation of that, I want to add few things. As the chairman said, the procedure is very simple. And anybody can approach the commission, not only the victim and not only anybody, any of his friend and all those things. A simple white paper with few lines regarding the cause of action and the offense and the name of the other person and the victim. Those particulars are enough for us to take cognizance of all those things. And the procedure that we are following at present now is that whenever we receive a petition or on sumo to cognizance by seeing a paper, electronic or print media, we issue notice if necessary that we feel. We issue a notice to the collector, SP, whoever may be the authority to whom the matter pertains to. We ask for a report to submit by so and so date. And the presently, after this commission is formed, the response from the officials is very good. And they are submitting the reports within time. After getting the report, the procedure is we serve that copy of that invariably on the applicant. And then we seek his response in the shape of a reply. Then after receiving the reply, we also, if it is necessary, we give that copy of that reply to the authority also. Then we conduct a hearing of both. Then we pass an order. This is the procedure we are following. The achievements of this commission within the just 2-3 months we actively worked, because after March 30, 21, this COVID-19, practically this commission is only taking up the daily applications but not conducting the courts, regular courts. The achievements are so many. The achievements.
The respected Honorable Chairperson and respected Honorable Member Judicial Garu and Mr. Vamsi. It's nice that we are all online conducting this session to bring awareness among all the junior advocates. And I'm very happy that the Ramesh Babu Garu has expressed his views very well. And our chairperson, Honorable Chairperson, has elaborately explained about the differences between the courts and the Human Rights Commission, and which was supported by our Honorable Member Judicial Sri Anand Ravaru with regards to the cases taken up and the institutions and disposals. I'm very happy that Mr. Vamsi has taken up this initiative. Let us continue in these aspects for the purpose of newly joined advocates, or the purpose of the junior advocates who are yet to be trained in all aspects. And I already discussed with you with regards to the awareness to be brought among the junior advocates. So this is a very good program which enlighten all of us, in fact, not only the advocates and who are not participants among us, those who are not even advocates, they also can be having this awareness so as to publicize the rights of the people across the world and across the country online. I hope this will fetch a lot, and thank you very much for this opportunity. Namaskar.
Yes, thank you.
One word, Mr. Vamsi. I must place on record our appreciation to you
Thank you.
on conducting this webinar for the benefit of the young lawyers. It is not only the benefit of the young lawyers, but all the people of Telangana. It goes.
Very good morning.
1 minute, Amma. 1 minute. Very good,
Thank you very much, sir.
It is a very good starting. It should go on. I wish you all the best, and see that as many as possible the people who have the opportunity of watching this program should be made available to them by free intimation to all of them, particularly
Yes,
the lawyers. Thank you. All the best. God bless.
Thank you very much, sir.
Very good program, Vamsi. Really very good program. I would like to just tell here, I'm also a solicitor of UK. We have continued legal education, which we have to, every year we have to count, at least 40 hours we have to participate in continued legal education. Every solicitor has to do that. So that, which is lacking in India, Bar Council of India has not prescribed such continued legal education. But at least through Mr. Vamsi, if this program can be made as a continued legal education, making such programs every month, or at least in a year span, schedule some programs to educate our advocates fraternity, it would be really helpful, and I appreciate on this. And I thank my Lord Justice Chandraya Garu, who has really given valuable suggestions and information in this program today. Thank you.
Thank you very much, sir.